Are y'all in agreement that something was mislabeled and something's been properly labeled now and that everything is in good shape?
I think so.
And both parties agree?
Is it just
What the new number is?
Yeah. What is 31 is apparently is an envelope that has inside of it a disc, and that disc is 32 now, and has been. The other item that was 32 is another disc, which is the Lenovo ThinkPad IEF report. That is now numbered 85.
Is that going to solve everything, Mr. Evans?
Solves my problem, not it. I assume you want to say something about that in front of the jury too, so they know what it is we're talking about.
I don't know if we need to do that, but we can if we do.
What is it you want to have done?
Well, I just don't know if there's going to be any confusion for them about what we're referring to, so that her no tendering officially of an 85, but it matters not to me. I'll just refer to it to what it is.
Well, is it in evidence?
It is. It just has a different number, and they don't get to take those back with them to the jury room anyway, so I'm not sure why, but we're going to have to put that on the record if need be.
Brian, are you satisfied with the record? Is everything together properly? Mr. Evans, if you want to explain it, you can, and if you don't have to.
I'll let it be.
But that's your call, and you can do it if you want.
Yes, ma'am.
Are we ready to go forward?
I am.
Bring the jury in.
All rise for the jury. Please like yourself.
Ladies and gentlemen, I hope you enjoyed your lunch. We're ready to resume the trial of the case. Mr. Evans, you can proceed when you're ready.
Yes, ma'am, thank you.
You're welcome.
During the lunch break, we're sorting through some evidence sticker issues and also some other issues involving a date that I incorrectly asked you about. So I want to make sure we correct that because that's important. First thing is, did you review what we refer to as the, of course, what we've referred to as the hot car video recovered from defendant's Lenovo?
I did.
Okay. And that was accessed on June 13th, 2014, is that correct?
That's correct.
Okay. I mistakenly asked you about some vacation searches and used that same date, but that's a different date. Is that accurate?
That's correct.
Well, while we're on the topic of the hot car video, let's talk about that for a second, and then we'll get to this. For the hot car video search, for the hot car video.
Judge, I'm going to object to Mr. Evans referring to this video as the hot car video. That's not the title. That's not what's in evidence. So I would object to his characterization.
What do you say, Mr. Evans?
I can refer to it by item number if need be. How about this?
As long as it's accurate.
Did you observe the video with the vet in the hot car?
I did.
Per the extraction report, that video was accessed twice. Are you aware of that?
Yes.
Let's talk about the term access, if you could describe for the jury what access means.
In digital forensics, there are really 3 dates that we pay attention to. One is called created. And created is simply when the item first came to the computer or to the device. So I want to download some picture, when it first gets to the hard drive, it gets stamped with that created date. A modified date isn't entirely labeled correctly. And that's in part because Microsoft didn't really review it as a forensic term, but just as a user term. But what modified simply means is that there was human interaction with it. I reached for the mouse and I touched something, or I used the keyboard and I navigated to something. And then you have the last access date. Really what that date means is that the file is still on the computer. It's not human interaction. It's either antivirus may have touched it, or it's human interaction. It's a 50-50 split. Since we don't know the difference, we come to agree that it is an item that's actually on the computer hard drive. So again, your modified date is really what's the most important part. That shows human interaction. Sure, created date might reflect that, but that could be something reflecting from an auto download or something that came to the system. It's that modified date that you want to look for, because that's human interaction.
And did you see evidence of human interaction regarding that particular video?
I did.
Okay. And were you able to determine the pathway of how the defendant was able to view that video through his Lenovo?
I did.
Can you explain to the jury what the pathway is?
Okay, it all started with a website called Reddit. Reddit is social media. Lets you post comments, it lets you put articles up, it lets you put files up or whatever. And it's not just one particular item, it's a multitude of items. Again, you could have pictures, you could have documents, you could have videos, you could have everything all on the same page inside Reddit. And then you see an item that you might be interested in and you would click it. Now, two things can happen. One is what we call a redirect. Takes you from the Reddit website and might take you to another website like Microsoft.com or some other website. Or it stays within the Reddit website. Either way, when you click the link, something's going to happen to it. In this particular case, when the link is clicked, you can see it goes over to YouTube. YouTube is a video sharing software application web service that when you click the link, the video that you click the link of will start playing the video.
In this case, you saw that human interaction that proved that that video was clicked on because it was redirection?
Yes. Now, again, remember that on that web page you have a variety of different things, but this one particular video you can see clearly was clicked, redirected to YouTube, and played.
Now, it goes without saying the extraction from a device is not the exclusive way to determine whether somebody viewed that video or not. Would you agree with that?
I would agree with that.
For instance, the defendant could have admitted as much during a custodial interview.
Absolutely.
And if he did so, then that extraction would corroborate what he told the detective that he viewed the video.
Correct.
Having now cleared up that date issue, I want to talk about what happened after that in the search that you just talked about before our lunch break while we're trying to get our technology sorted out. Again, I apologize. Let's talk about that. Do we have the extraction of the Lenovo now up and displayed for the jury?
Yes.
And if you'll step down with me, I think it'd be easier if you come down here. So with this full extraction up before the jury, I asked you some questions about a search for a vacation involving 2 adults and no children. You saw that, correct?
I did.
What's the correct date? Not the date that I gave you, but the correct date for that search.
That would be the 17th of June, 2014.
June 17th, 2014. Where can that search be displayed?
Now, it actually starts right here. I'm going to make this a little bigger so that we can see. Now, remember, we talked a little bit about web data. Some of the elements you got to take out. For example, we have, here's the name of the website, Sandals, and then just below it, it has Sandals, the and sign. That's not an actual person typing that. It's part of that query. That's part of that lookup that we're doing. And then you have NO, number of adults equals, and a number 2. So we know that while at Sandals, a search was done for number of adults 2. The ampersand again is the next step over.
number of children equals 0. So what we have in this link that happened on the 17th at about 7:47 p.m. is a search at Sandals as you're starting to book for 2 adults, no children.
And what is can you actually see, looking at this code, anywhere through any of these searches, the dates that were entered as well?
I can, and let me scroll up there a little bit. When you book a reservation on a website such as this, you're prompted with 2 fields that you have to fill in. And what they do as a matter of convenience is they will put the date that you're actually at that location, at that site. It will autofill that information with the date that you're actually doing your searching with or your booking. So if we look right here, you'll see where it says calendar start date is 7/22/2014. If we look at arrival date, it says June 17th. Again, that's an autofill date that's picking it up from over here. It does that as a convenience to the user. It autofills that. You make the adjustments. That's what we see in the start date. And it's waiting for the next, the arrival date to get filled in.
And what was the arrival date that was filled in for this import?
The start date here is 7/22/2014, and it shows August 22/2014 as a second start date, but the arrival dates are showing this June. Again, that's the auto-populated. The calendar start date is going to be July 22nd in this sense, and then you see an August 22nd in this sense. So what we're doing is we're auto-filling this query twice, with two different dates that all come off of that no adults, 2 adults and no children.
All right, sir. Let me have a seat. A few other topics I want to cover with you. First thing is, I had asked you, just as an example, about some demonstrative aids that you prepared. And looking at 921, you had pointed out a particular company here having to do with psychology or psychiatry and things like that, and involving the criminal justice system. Remember that?
I recall that,
Okay.
yes.
Are you aware that the defendant was doing some web work for that company?
I was not.
Okay. Looking at this and understanding that he was doing some web work for that company, were you simply using this as an example of how the codes could be read together?
Absolutely.
Let's talk a little bit about some investigation you did into some divorce queries. Did you find anything like that?
I did.
699, excuse me.
Did you take those 2 days?
I did. Showing you 929, flip through these documents and see if you recognize what those are. Were those provided to us by email after you located them?
It does.
Okay. And these are fair and accurate documents that were recovered from the extraction report, is that correct?
That's correct.
All right, tender states 929.
Simply subject to the previous objections that we made about some of these electronic devices, Judge. Or all the electronic devices, right?
Admitted.
All right, we can start with this first page. When it says full path here, we're talking about the Lenovo ThinkPad, is that correct?
That's correct.
And why don't you explain, it's very hard to see, so I'm going to let you hold 929, and looking at that first page, explain exactly what that is from the Lenovo.
As you saw in the preferences that I talked about, that path that's at the top, they generally start from the forensic server of which we use to analyze the data with. As in this case, there is a folder called that starts out as Harris. That's my machine. After that, there is a series of numbers followed by a -1. So it's 250984-1 followed by Lenovo ThinkPad. When Cobb County makes a forensic image, and again, remember, that is an exact copy of the original. That's what you work from. They give it a name per device of whatever they want to call it. And then it follows with C, which is the main part of the hard drive, the C colon. That's where Windows operates from. And it says users. After that, it has J as in Juliet, X as in X-ray, H as in Henry, 3528. Now that's important. That's a computer user's profile that's on that particular computer. So it shows that the person using that username is actually logged in with the proper credentials in order to get in it and is about to use the internet. It follows with app data, local, Microsoft, Windows, and then temporary internet history or internet files. That again supports this is web history information. As it goes on, it talks about it has a folder called content.ie5. Now that gets a little confusing, but IE is Internet Explorer. That's Microsoft. That's what comes with the computer. The 5 was back when they had version 5. They called it with a 5 there, and they've never changed it since. So even though today we're operating under 11, it still has that 5 that you'll see in there. After that, it has a series of alphanumeric letters. That is a folder that's inside the temporary internet history. After that, the name of the web page is this: Divorce Legal Separation Checklist with a number 1.htm. So that's a web page that deals with, once I opened it, a checklist involving divorces.
What's the date of that inquiry that you found on the Lenovo Mr. Harris had in his possession when it was seized?
May 9th, 2014 at 11:39 a.m.
May 9th.
Correct.
Talk about the documents in order. The second page, what's that we're looking at?
The se-
929.
The second page is the actual content of what you would see when you launch that web page, when you actually open that web page.
And looking at this, what's generally the subject matter associated with that once you launch that web page to confirm what it was?
Divorce legal separation checklist, and then it has steps of which you should follow.
What's the first step that's listed, for example?
If you have decided to change your legal name, your emergency contact information, and or change your address and phone number, you should update them through employee self-service on My Apron or another website that belonged to his employer.
Home Depot.
Correct. And so what this shows is that there was a search. And some of the data in this exhibit shows that there was a search, and that this search was done on Home Depot's corporate website, most likely internal, their intranet.
There are additional steps here as well, 2, 3, 4, and 5. We don't need to read all of them, but the 3, for example, deals with what you should do with your W-4 form. Is that correct?
Correct.
And then this will be before the jury, so we'll skip on to the next several pages, which all look similar to each other. At least the first 3 of those pages. Can you look at those and explain the significance of that?
Yeah, page 1 here at the very top, which is important. You will see where it says, "Welcome, Justin Harris." Now what that's saying is that a user sat in front of his computer, logged into the Home Depot website as Justin Harris. And it says a date next to it of May 9th, 2014. So we know that he was logged into that website at that particular moment. And then just below that, it has a search criteria. If you've ever been to Google, you know right in the middle of Google has a search bar that lets you look up things. You're looking up movie times, or you're looking up a particular movie, or how traffic is, you would type that information in Google, and Google would go get it. This works the same way. In this case, the search criteria he put in was name change. and the results came back as a result of that, which was this checklist for the divorce.
Okay. And all of those documents referring to the search are from May 9th of 2014, correct?
Correct.
The vet video that we talked about, vet in the car, that was June 13th of 2014, correct?
Correct.
And I think I may have said the number, let's make sure we get it perfectly right. 5/9 of 2014 for 9/29, is that correct?
Correct.
Okay. The vet video is 6/13 of 2014, correct?
Correct.
The search that we just looked at for 2 adults, no children, June 17th of 2014.
Correct.
Final piece of evidence I want to ask you about is a whisper post. And you were asked very early on to look at a whisper post that was found embedded in the iPhone 5 extraction. You recall that?
I do.
When we first look at this, and I'll give you by way of example 399, when we first started looking at this in 2014, was the full exchange of the contact between defendant and this poster revealed or uncoded with that version of Celebrite.
No.
Can you explain to the jury, well, that's kind of a mouthful, is that uncommon, and can you explain why it is we weren't able to see the full chat at first?
Sometimes it's just the limitation of the software. Again, that's why you have updates. That's why when they tell you that your Windows needs to have patches done to it, you need to do it because new things are going to get discovered to you. It's no different in my world. In the forensic field, it's very common that update to software potentially is going to reveal new information even with old data, as in this case.
You're aware that subsequent to find this initial post, because of a software update, we were able to reveal or decode the full conversation between the defendant and the person who posted this. I hate being married with kids, correct?
Correct.
And now I'm going to show you states 400. Looking at 400, did you go back and look at the extracted data from the defendant's iPhone 5 to review that chat as well?
I did.
Okay. And looking at states 400, the times are correct here. It's adequately reflected that we got the UTC -4.
That's correct.
And why is it that we were later with an updated version of Celebrite able to decode the full conversation between defendant on the morning of June 18th, 2014?
The software just missed it in its earlier version. It, again, very, very common. That's why my field search is now on version 5. Software has to get smarter because even old data gives you new results.
And is there anything remarkable or uncommon in your professional experience with Cobb County having obtained, upgraded software to be able to run new extraction reports?
Now, I highly recommend it. Doesn't matter if I'm doing defense work or if I'm doing prosecution work, if I'm doing civil work. Always, when you get your updates and you've got cases that are coming to trial, you run it back through it.
Thank you.
Just in that same vein, you're aware that there was a new version of Celebrite, I think it's 4.2.6, that was used in this case.
Correct.
And you're aware, though, that the forensic analysis report, you said it very simply as running it through the new software version. And running what through exactly?
It's a good question.
Thank you.
When we do an extraction of a cell phone, we talked a little bit earlier about it being the dump file. That's the whole entire contents of the device. So you take that dump file and you run it back through the new updated executable, the new Celebrite software. Again, it doesn't change that dump file. It's just going to revisit the information and show you potentially new information.
And the jury heard about this with the 3 previous digital forensics experts that were called from the high-tech crimes unit. But just so that we can orient ourselves, there's 3 levels of extractions that Celebrite can perform on a phone, correct?
Correct.
And the highest level is
The physical.
the physical. And you know that that highest level of an extraction wasn't done on the iPhone 5S.
Correct.
As Celebrite's software progresses and advances, is it now possible to do a physical extraction of an Apple iPhone 5S?
My experience has been, since I don't have this particular device at my lab, it was at Cobb's lab. I've had iPhone 5s before that did offer, but when trying to run it through, it failed. So, as he just pointed out, the three different processes that it allows you, the physical being the best, your file system is the next best. So when you get things that fail, and they develop a history of failing on the physical, you roll back to the next one that you know is good. So the iPhones I've had come in that are iPhone 5s, I may start with a physical, but if it fails, I'm going to roll back. And I'm going to do only that, which one of those three that actually work.
When Celebrite version 4.2.6 came out, do you know if high-tech crimes with Cobb County Police tried to do a physical, the highest level of extraction, and it failed? Or do you know if they just didn't bother to try?
I don't know either way.
Either way, we don't have a bit-by-bit copy image of that telephone.
What I have is what we call the best bit by bit. In my case, because I have the file system, that was the best. So in my opinion, I would say that I have the best, closest to the bit by bit copy of that.
Well, how do you know if you have the best if Cobb Police may not have even tried to get the best?
Only thing I can tell you is that I was provided a copy of the file that included when they did the file listing of the data. So I don't know what Cobb did because, again, my direction came from the DA's office. I knew that when I reran it through new updated software, I got new information.
Okay. And can you think of any reason at all, as a digital forensics expert, why you wouldn't try to get a physical extraction, the highest level, the best level, now that Celebrite has rolled out a new version of the software?
I can only think of one, and I don't know that it'd be so much technical. Maybe they thought they needed a search warrant to redo it. I don't know.
Okay, well, fair enough. You weren't involved with applying for search warrants.
No, sir.
The lead detectives in the case were, right?
Yes, sir.
Detective Stoddard,
Yes, sir.
Detective Sean Murphy.
I don't know Sean Murphy.
Did you not deal with him?
If I did, it was very brief.
Okay. And now let's talk about who directed you to do things in the case. You said that you don't know why or what Cobb County Police did. You took your direction from the district attorney's office.
Correct.
Did you ever meet with the lead detective, Phil Stoddard?
I did maybe 2-3 times.
And when were those meetings?
The first one was early on. I want to say probably mid-July 2014.
Right.
It could have been a couple of months after that, less than 6. I met with him a second time. And there may have been a third time within, say, the last 18 months.
The last 18 months starting today?
Yes, sir.
And you testified on direct that when you first met, that you started working early in July of 2014. It's true, you were contacted by Jesse Evans on July the 3rd, 2014.
That sounds about right, yes.
Were you aware that there was a probable cause hearing in this case on that very day?
No, sir.
So you don't know if you were contacted before the probable cause hearing or after?
No, sir.
And we've got your report, so we have the benefit of knowing exactly what the district attorney's office tasked you to do. And before we go through it, you'd agree that your focus, the most important part of your task and your responsibility was on two elements, as you call them, correct?
Yes, sir.
The whisper, that's the red image. This one here,
Yes, sir.
states $3.99.
Yes, sir.
We know that Ross did not create this meme, correct?
Correct.
And you were tasked with finding out if Ross created this meme, correct?
I think it was twofold.
Okay.
If he actually created it and any other data that may be around that.
And that was a question at that point, correct?
I believe so, yes.
For Cobb PD and the district attorney's office.
For the district attorney's office, I know.
Okay. You don't know if Cobb PD knew whether Ross created that image or not.
Correct.
And then the second element was the vet video.
Yes, sir.
You've been involved in this case for over 2 years, correct?
Yes, sir.
You got engaged July the 3rd, 2014. We know that that was just 2 weeks from the date of Cooper's death, correct?
Yes, sir.
Were you tasked at all to determine if there was any evidence on any of these electronic devices of hatred or ill will towards Cooper Harris?
No, sir.
You weren't asked to do that.
Not specifically those words, no, sir.
Okay. What words were used then?
To find any information that may relate to that particular video to the whisper chat.
Okay.
Regardless of content.
Okay. And objectively, those two elements that you were tasked with focusing your work on, objectively, have nothing to do with hatred or ill will towards anyone.
Which is that one's argumentative. I think the piece of evidence speaks for itself regarding the states and things like that. So I think it's argumentative to ask it that way and cause for speculation as well.
Ms. Town.
Originally, though, you were tasked with doing much more than just focusing your work and efforts over 2 years on a vet video and a whisper image, correct?
Now, originally, those were the two topics.
You testified on direct that you met with detectives, the district attorney's office, to go over all devices and identify what issues they may have, correct?
Correct.
We know that the vet video, evidence related to the vet video, is found on one device, correct?
Correct.
We know that the whisper image that the state believed Ross created was found on one device.
Correct.
Yet, from the very beginning, you were asked to go through all devices and in your work with the state, identify what issues they may have.
I don't think there's some missing elements in your question, if I may. There's a difference between going over and analyzing. I wasn't tasked to analyze everything. I was tasked to look, one, procedurally, make sure that what Cobb was doing I felt was correct by industry standards. Because I've had, when I work inside of defense, I've had law enforcement agents not do it correctly. Second to that, the tasks were very specific. Where the data was more or less my investigative skills coming out, where we're looking for whisper data, and I'm handed forensic images of 2 or 3 different devices. I'm going to do a general scan just to see where that data may be. And so that's what an investigation does, is it unravels in different directions.
when you met with the Cobb District Attorney's Office and detectives assigned to the case, did they go over very specific questions for you?
The only question that I can remember was if I had any exposure to Whisper. Outside of that, I don't recall anything else.
Do you remember being told that they were 80% sure that Ross created that red image?
Judge, objection, and that will call for hearsay as well. One, it's not accurate, and two, it would call for hearsay with what somebody else told him.
Save your question, Tim.
At this meeting where you were asked one question, or at least you can remember one question, do you recall being told that they were 80% sure that Ross created that red image?
Right, so that would
I'll
be.
sustain the objection.
Were you 80% sure that Ross created that image?
I wasn't sure about anything at that point. I was brought in relatively new. I was handed a few copies of data on disks and started to get ready to go to work.
You wouldn't jump to conclusions, would you?
I don't know that I understand that question entirely. Can you rephrase, please?
Yeah. In relation to the red image, you just said, I wouldn't assume anything about that red image, right?
Well, the only thing that I can make an assumption, if I'm going to make one, is who the user might have been holding the phone. Outside of that, there was nothing else to tell until you ran it back through the Celebrite update, because then you got the rest of the communication, and you could see the green little character in the chat was clearly going to be who's using the cell phone.
But just looking at the image, the meaning, right? You wouldn't just look at that and assume that Ross Harris created this image.
Objection, asked and answered, and argumentative, and calls for speculation.
Judge, I have him across, and he's an expert. He was tendered and offered as an expert. Specifically, this is one of the elements that he's been working on over the last 2 years, and I'm following up from his testimony, which was, I'm not going to assume anything about this image other than who maybe the user is of the phone, which is
I'll
great.
vote over objection. You can explore it a bit.
You wouldn't just assume at the very beginning of the case that a user created that image, right?
I would not assume that. That's correct.
Because your role as a private investigator, okay, forensic consultant, is to actually do some forensics, right?
Yes, but again, what Celebrite provided was the picture. We talked a little bit about the created file when that comes to a computer and how that has a play of human interaction and that modified is human interaction. With just that picture, nothing else around it, you can't say 100% sure that that was user created, but you can't rule out that the human that had access to the phone created it either, because you have a created file. So it could have been, but it could not have been as well. It's like 50-50.
I think it's 50-50.
It's either a human that owns the phone or somebody from the web and he downloaded it. It can only be one of two.
Would it be helpful to just actually look at the image? You called it 50-50. But if you read the content, I hate being married with kids, plural, correct?
Yes, sir.
Knowing that Ross only had one child when that image was created, would that lower, or would that affect your 50-50 chance of it being Ross Harris?
Well, one thing you said was knowingly, that he had no, if I knew that he had one child.
Right.
I can't even answer that because I don't know if she could have been pregnant at the time and that would have been kids to him. I don't know those things.
You weren't provided with, I guess, more information about the context or about who Ross is to make a blanket assumption that affects your 50-50 chance of who the creator is.
Correct.
Okay. Well, that's fair. Nobody told you, though, that Leanna Harris at the time was pregnant.
No, sir.
And in fact, all you knew was that Ross and Leanna had one child.
I only knew that from what little clip I got out of the news. Outside of that, nobody told me anything about number of kids.
But luckily, you didn't stop there. You actually investigated this image. And we now know that Ross did not create that red image. And that's because of the limitations of Cellbrite, as you discussed. Correct?
Yes.
Because now a new software version has come out, more information can be gleaned from the phone. Correct?
Yes, sir.
So simply because there may not be evidence of something on the phone, or let me put it this way. Just because when that first analysis was done, Cellbrite couldn't connect the chats with that image, doesn't mean that Ross did anything to hide it or delete it in any way. Correct?
Correct.
Just because Cellbrite can't detect something that's on that phone doesn't mean that Ross hid or deleted anything. Correct?
Correct.
Are you familiar with applications like My Hidden Folder Pro or AVG Cleaner?
AVG Cleaner I am, yes.
Can you tell the jury a little bit about that application?
It serves two purposes. One, to try to speed up your computer by getting rid of data that you don't want. Unused, unwanted, old, whatever you want to term it as, but to get rid of that old information that helps speed up your system. Second to that is it will prompt you with some messages that say, hey, certain things are out of date and probably ought to update it.
Given your understanding of this application, someone that has it downloaded on their phone, it doesn't necessarily mean that they're trying to tamper with evidence or hide evidence from anyone, right?
Not the use of that application, no, sir.
Well, we've heard questions posed to other experts in the case in digital forensics. You're not aware that there was any sort of application like AVG Cleaner on Ross Harris's phone?
I am not aware of any, no, sir.
And in fact, Cellbrite can tell you exactly what applications were found on the phone, correct?
Cellbrite doesn't necessarily tell you what they are.
Okay.
It just lists them.
It lists them.
And sometimes not even by, you call it AVG Cleaner, we may see that on the actual phone, but Cellbrite may actually call the name of the file that may mean nothing to us.
Did you find a file that may mean nothing to us, but turns out to be AVG Cleaner?
I did not.
Cellbrite can also tell us if an application was originally on the phone and it was deleted, correct?
To a degree, yes, sir.
And you're not aware of any applications that were deleted, correct?
I can't say any because I didn't really investigate that portion of it. I can just say that in the Whisper application, I don't see that it was deleted.
Whisper was not deleted, correct?
Correct.
And so all this evidence here of filthy sexual communications with different women, okay, were not deleted. The application was not deleted.
Correct.
you familiar with applications that look like a calculator, but when you click on it, it's actually a place where you can save dirty photos or dirty chats?
I am familiar with some of those, yes.
Okay. That wasn't on Ross's phone, was it?
No, sir.
Do you know where the Whisper and Kick apps were located on his phone?
My understanding, it was buried inside of a folder that had the look of a different app would. It wasn't on an iPhone, they call them tiles. Your little apps are tiles. So it wasn't a tile. It was in a folder that was buried in with others.
It wasn't hard to find that Whisper app, was it?
In Celebrite, it gives us a file listing. So no, it wasn't hard to find it just by looking at the file listings. Why? Because I used a search term called Whisper. Found it right off, didn't take any time. If I was to look at the phone, just at its face value, it would probably take me a while to scroll over to it.
Right? 10 minutes, maybe?
I don't know, I hadn't used his phone. The more stuff you put on it, the slower it gets.
Well, just to open all the folders on the apps, I mean, some of these jurors may have iPhones, and they may be familiar. You would just need to scroll through the different folders to see where all the applications were stored and organized, right?
Yes, I mean, you gave me a time limit of 10 minutes, maybe it takes me 15 minutes.
Okay.
I don't know.
Less than an hour, for sure.
I would agree with that.
Okay. And certainly, over the span of 2 years, someone could easily flip through that phone and find out exactly where those applications were buried, as you said.
I would think so, yes, sir.
Certainly not difficult for law enforcement or a digital forensics expert to locate this application. Maybe a little more challenging for a wife. Wouldn't you say?
I don't know the wife's skill sets. I've had some wives be real familiar with iPhones and iPhone data. So I couldn't say in this particular case, but again, I wouldn't think it'd take too long.
That's fair. You've worked divorce cases before, right?
I have.
Where one spouse is hiding stuff from the other, correct?
Correct.
Now, on direct, I noticed you spent less than 5 minutes talking about this vet video, which is one of 2 main components that you were tasked to do over the span of 2 years in this case. So let me spend a little more time with you on it. You attached exhibits to your report to kind of show exactly the time when this YouTube video was visited, correct?
Yes, sir.
You listed the website that referred the user from Reddit to YouTube.
Yes, sir.
You talked about the modified date, last access date, and created date. Not 86.
That's
For sure.
check. 86.
Thank you. I'm handing you what's been pre-marked for identification purposes. Appendix 86. You recognize that as one of the attachments to your report that you created in this case, correct?
Yes, sir.
I'm going to move D86.
I don't have any objection.
And if you look, and so the jury understands, this report, this screenshot, is this of your computer?
I'm not sure I follow on that question.
Where did this come from?
Well, it came directly out of his data, but what I do is I create a web page, and then I size it, and I do a screen capture of that web page, and that's what that represents.
So you actually created the format that contains the content found on the Lenovo.
Yes.
You created the table, right?
The table gets created actually by the software as a default. I just take that and do a screenshot of that while it's in a web page form to do the screen capture with.
And what software is that?
It's web-based, so it's just,
I know, but what software did you use that you said creates the tables and the columns?
you mean which forensic software?
Yes, sir.
That would come from the, if I may refer to my report.
Sure. Let me get that for you. Would it be fair to say it's not the same IEF report that Cobb County Police High-Tech Crimes used? It's a different software, right?
It's actually the same software. It's just that what they give, when they do a full extraction, it has countless rows. Countless rows that go all the way down here. Some of it is, it'll talk about hash values, it'll talk about, path from the forensic server, it'll talk about how big the file is and some other attributes. This here was reduced by the number of columns.
I'm showing the opposing counsel list and pre-marked for identification purposes is D87.
So to answer your question, it's first generated by InCase. InCase creates a HTML web page. I then parse it by using a different application that is made by a company called Nursoft. Nursoft allows you to control those different rows and columns that gives you a much cleaner look. Doesn't change the information, but it allows you to reduce that down. Otherwise, we would need a billboard in order to print this whole thing. Since this is the part that felt relevant, I created the web page looking like this and then took a screen capture of that.
And I'm showing you what's been pre-marked as D87. That's the IEF report for, well, it contains the same information that comes from the Lenovo. And as you said, it's not in as clean of a format as the Nursoft software that you use, but that's what high-tech crimes with Cobb County Police uses, correct?
Yes, sir.
All right, I'll leave D87.
Okay.
And you would agree that here we're looking at the Chrome web history, which is exactly what you were looking at with your attachment, your exhibit. And you'd agree that on June the 13th, take a look at that last row there. The time is in UTC 0, right? So you need to subtract 4 from the time.
It doesn't say that it is, but yes, at the very top column it has a UT, so I'm assuming it's UTC. So yes, you would have to do some subtraction there.
Okay. And if you subtract 4, that would put it at 4:59:09 p.m., correct?
Yeah, 87 is just tough to read because of the number of columns in it. But that's what it looks like, yes.
And this comes from the state's evidence. You'd agree that it has a column where it says how many times that video was visited, correct?
Yes, sir.
Okay. And how many times does it say there?
2.
Okay.
Well, it says he went there twice. He clicked on the link twice.
Take a look at your report. Isn't it true? He did not click on that link twice. In fact, that's exactly what you found in your report.
If you could refer me to what paragraph we're talking about.
Your conclusion. Just read that to yourself and let me know when you're ready.
It doesn't have anything about the number of times. It just says the user clicked it, in my opinion, that the user clicked the video link in Reddit and was, in fact, redirected to YouTube where the video would automatically play as a result of the mechanisms both in YouTube's website.
Correct. And then D86 shows that it was clicked 4:59:09, and then at 4:59:10, 10 seconds. Right? That's the second visit, correct?
Correct.
Right? So he only clicked on the video link once in Reddit, and then it automatically redirected him to YouTube where it refreshed, correct?
I'm not agreeing with that. In fact, I disagree. One, we don't know if refresh was even activated at YouTube. Second to that, nothing in either one of these documents that you've presented indicates that he clicked twice inside Reddit, once inside Reddit. What we know is because it's visited twice, he saw it twice. We don't know where. We know it was redirected. We know it landed on YouTube. And we know there factually because there's two what we call URLs that show that they was actually visited twice.
Okay, when are the two times that he visited that video then?
You say, why is the timer?
When?
I'm sorry.
What are the two times that he saw the video, that he visited the video?
Both on June 13, 2014.
Right.
One at 4:59 and 9 seconds, and the second one at the same date at 4:59 and 10 seconds.
How
So,
long is that video?
several minutes.
Almost 6 minutes?
I would agree with that.
You agree it's impossible to watch a 6-minute video within 1 second?
Sir, this isn't indicating how long he watched it. For far as I know, he had two tabs open. Since he's a multi-user of multi-browsers, he could have had two tabs open and watched the video on two different tabs within his browser. That's not uncommon. I've seen that a lot.
You don't, I mean, there's no evidence of that. You don't know if Ross did that.
I don't know that he didn't do it either.
Sure. Over 2 years of work, you never included in your report, it's possible that Ross Harris watched this 5.5-minute video 2 times. You never said that.
And that is correct.
The state didn't ask you to offer that opinion, correct?
No, I believe the document stands for itself. It actually says, not only using Cobb County high-tech crimes method, but my method both indicate visit count that is generated, that column name is generated by the software. The forensic software titles it that, not us forensic specialists. It called it visit count, and it plugged in a number 2. And if you look just above that, there's another video that's called How to Guarantee You Win at Home in SEC. It has a number 1. We talked about a little bit that Reddit is not just this one video. It is a bunch of stuff. By percentage, majority of the stuff on that Reddit page that showed in the forensics, by majority, only 1 count. There were a few where you had 3, and a couple you had 4. You have a 6 in this one down here that deals with Home Depot. So 6 different times he went to the Home Depot website.
Because he's a web developer for Home Depot, right?
Yes, sir.
Okay.
But If it shows strong interest, you have 6 different visits to that. Majority of them have 1 visit. This video that involves this doctor and the dog in a hot car, twice.
You're saying it shows a strong interest in the vet video?
If I take my calculator out based on a percentage of calculation of how many different entries on that Reddit, and more than 80% of them are 1, it's more likely he had more interest in that 1 link than those others that only had 1.
Did you do that in this case?
I looked at all of them.
Did you punch in a calculator and determine the percentage of links clicked on?
I took in my own mind that I had multitude of entries in Reddit. And I scrolled through, visually approximating how many of them had a 1. How many of them had more than 2.
And how many?
Majority of them have 1.
Give me a number.
80%.
You would agree that there was never a parsed search for how hot does it get in a parked car? Correct?
I searched for that,
And you didn't find it.
but I wrestled with it. And here's why. You see, in the forensic world, we're very specific people. If you hand me a dictionary and tell me to find a word in it, I'm going to ask you what word. I'm not going to just look for every word. So I tried things like hot car, and I didn't get anything. But then I said, what words do I need to use? Hot car with a youngster, hot car with a toddler, hot car, hyperventilating child, all those different variations. How many do I try? And I said to myself, in the years I've been investigating data, I'm going to start it at a different approach. I'm going to look at his web history and see what common terms he might use to search data with. But the history was gone. Majority of it was deleted. So I couldn't start with anything. After putting in just hot car, I knew I couldn't put any other words in. I couldn't put in kids. I couldn't put in children. I couldn't put in child. I couldn't put in just so many different words come to mind. There's just no way to do that without having something to start from. That's why the results turned up with just hot car. No, I got nothing.
You testified on direct, though, that Chrome was the only explorer where the web history had appeared to be deleted.
That's correct.
There was Firefox.
Yes, sir, and I searched that diligently because the data was available.
Right.
So what did I find in there? Searching out high schools in Cobb County. I don't know why, but there was a bunch of that.
Maybe because he's a high school football referee. Did you know that?
I did not. But
What else did you find?
I found where he was looking up guitars.
Maybe because he plays in the church band.
And I play guitar, so I identified some of the websites that he'd been to.
What else did you find?
Where he was checking for patent information and Home Depot information and job offers and some other elements. So Firefox was all intact. I could search it. But Chrome was not.
Right.
And that's that Dr. Jekyll, Mr. Hyde. It was well hidden on the Chrome, but in the Firefox, it was all available.
He wasn't hiding the vet video. He told the police that he watched it. You know that.
Object, it's argumentative.
Judge. I've
But
got it on record.
that wasn't a question. Even if you have them on cross, it does have to be.
I'll rephrase. You were aware. And he was asked on direct. Ross Harris told the police that he watched that vet video. Correct?
Yes.
He didn't hide that vet video.
The vet, he didn't hide it. However, remember, the Chrome history was deleted June the 6th. Everything before that is off limits. It's gone. June the 6th. But June the 13th, that dog video came out. Maybe he's crafty enough that said, I got to tell him about that because I didn't hit the delete button to get rid of my history. He knew that video was there.
Maybe he was crafty enough?
I've done a lot of cases. I've had some outwit me. I have chased people all over the globe for lots of government agencies. Intentional move. But yes, I think he was crafty.
Do you think he was intentionally clearing his cache?
Yes.
There are a number of reasons why one would clear their cache, correct?
Yes.
It doesn't necessarily mean it's nefarious, correct?
Correct.
You know he's a web developer, right?
As I am, yes, sir. I'm aware.